Good afternoon. I'm Denise Milne, Senior Manager of FASD and Children's Mental Health, as well as the co-chair of the FASD Cross-Ministry Committee in Alberta. So welcome and thank you for being patient with us today. So you're at Pat Wazinko's session on FASD and practice issues for the defense. So again, welcome. Before I introduce Pat, there's a few housekeeping tips I need to bring to your attention. We are using a town hall format in which you can submit questions for the speaker by email to cys.fasd@gov.ab.ca. Again, that's cys.fasd@gov.ab.ca, or by texting 780-405-3376. Again, the texting is 780-405-3376. And Pat will respond to your questions, and at the end of the session and throughout the session, we'll bring that back up. Again, if you have any questions after the presentation, you can contact Pat. She's got her contact information at the end of the handouts. Today, we're pleased to announce that there are 61 sites on board from BC, 5 sites, Yukon, Northwest Territory, Nunavut with 4, Saskatchewan with 11 sites, Welcome Ontario with 4 sites, and the remaining 37 sites in Alberta. Again, there's about 125 participants today. And so that's quite fascinating for a very specialized event on practice issues for the defense with FASD. Again, we cannot stress how important education and training has become as a critical strategy for FASD in our 10-year strategic plan. The government of Alberta is truly committed to addressing education and training through the various initiatives such as video conferencing. Again, we're very pleased with the ongoing interest and attendance at the various sessions. Now I have the pleasure of introducing Pat. Pat's been practicing law since 1993. She's employed with the Youth Criminal Defense Office since 1995, where her practice has been restricted to the representation of young people in conflict with the law. She's a member of the FASD Justice Support Project for Youth, which arranges case conferences on FASD-afflicted young persons charged with criminal offenses. Pat's conducted a number of presentations on FASD, including the one most recently in Edmonton in February, as well as the May conference in BC. Obviously, she has a very strong interest in FASD, and we are thrilled to have her today to do a presentation on practice issues for the defense. So welcome, Pat.
Just as a couple of notes, if people have questions as I go, I encourage questions as I go. If I'm getting held up, if I don't think I'm going to finish the presentation, I may stop taking questions, but please feel free to bring them in or ask them as we go. The other thing I should tell everybody is I prepared this for defense lawyers. I understand a lot of you out there are not defense lawyers, so if you're bored or if I'm saying a lot of things that you've already heard before, I apologize, but just because professionals, medical professionals or child welfare professionals understand FASD doesn't mean lawyers do, so I am going to go into a little bit about FASD and the diagnosis itself. So I'm going to start with that, and then I'm going to discuss the diagnosis as it applies to the defense in court, mostly of young people, but I do consider some of the adult situations as well. And for those of you who don't know, in Canada, people between the ages of 12 and 17 are considered young offenders or youthful offenders, and 18 and above are dealt with in a different system in the normal adult system. So to start with FASD, what I'm going to say, first of all, is, of course, I'm not a doctor. What I've done is I've talked to a lot of people, I've gone to a lot of conferences, I've read a lot of things about fetal alcohol spectrum disorder, and I've tried to draw from that information and create information for lawyers that I think is relevant to the practice of law. So I'm not a medical professional, I'm just trying to bring in the information to lawyers and bring it to lawyers in a fashion that I think would be applicable to them. I would say this about FASD. I started practicing in youth court in 1995, and when I first learned about FASD, what I learned was that it happened because babies were exposed to alcohol in utero, and that it happened, what the effect was that they don't understand the consequences. And the only thing I really took from that is when they're sentenced in court, they didn't relate the sentence to the charge. And I'm sure most of you know that's a very superficial understanding of FASD, and over time I've come to realize that we need to understand a little bit more than connecting the sentence with the offense when we're dealing with FASD in the criminal justice system. So what I've done is I've started here with the terminology. Most of you will be familiar with that. Fetal alcohol syndrome, fetal alcohol effects, alcohol-related birth defects, alcohol-related neurodevelopmental disorder, and partial FAS. I think what you'll find is a lot of people will look at that and say partial FAS means they're higher functioning than somebody with a different diagnosis. From the perspective of a lawyer, it really doesn't matter what the diagnosis is. What matters is what the assessment is. What matters is how that diagnosis affects how that individual can conduct themselves. And for that reason, I think it's important that we don't get bogged down, and certainly from the lawyer's perspective, we don't get bogged down on the actual diagnosis and consider more the assessment. I think too many people would look at that and draw the wrong conclusions depending on the diagnosis. So I'm going to skip some of this. I should tell people, perhaps, maybe to help follow along, that you number the pages of the handout you were given. So I'm now on page 2 on the top slide. I'm not going to go into a whole lot of detail there. I think everybody understands that's FASD, the basics, what FASD is or how it happens. The next slide talks about the central nervous system, and I bring that up because I think a lot of people look at FASD, and if they don't see the physical manifestations of FASD, they don't understand that there's internal manifestations that we don't see, that the brain is still affected all the way through the course of the pregnancy if alcohol is consumed. So that's why I've included this slide. As a lawyer, I go to these things and people talk about the executive functioning. I don't know what executive functioning is, so I actually looked it up and put it in here because I think it's important that lawyers understand what we're talking about and how deep this impact has. So I've broken it down into categories, and these are categories that I think are very important for lawyers to understand when they're defending their clients. So if we go into the planning, ability to predict, organize, prioritize, sequence, initiate, follow through, set goals, be on time, adhere to a schedule. How does this affect somebody, for example, who's on probation, who has a number of conditions they have to follow and to do things in a particular way when they're having their own issues with planning and being on time and setting goals for themselves. Selective inhibition, that's another major issue. It affects the ability to actively inhibit a well-learned behavior. Well, what if the well-learned behavior isn't a very pro-social behavior and in fact is a negative behavior? When they go from one situation to another situation, it starts causing, if the behavior is acceptable in one situation, for example, the family home or with their peers, they may take that behavior into a different situation, not recognizing that it's not acceptable there. And suddenly, that which was being encouraged by family or friends, such as stealing a car, for example, suddenly they're getting charged for it and having a whole different consequence for behaving in that fashion. The cognitive flexibility, the ability to shift between different tasks, rules, instructions in a flexible way. Again, that causes a lot of confusion, and I think that a lot of people misinterpret that behavior as being willfully inflexible and willfully unwilling to do what's required of them in particular situations. And again, I'm talking about in a courtroom situation or when a judge is looking at a young person who has this kind of characteristics. If the judge doesn't understand or the lawyer doesn't understand the person has FASD, it affects the way that young person or adult is treated in a courtroom. Going on to concept formation, I should say this, the legal system is complex. Quite frankly, a lot of lawyers don't get everything that's in the legal system. A lot of clients don't understand everything that's in the legal system, and then you're now dealing with somebody who has brain damage, trying to understand the complexities. People who are charged with offenses have to make decisions for themselves. And as much as lawyers can encourage them to go one way or the other, it's always the accused who has the final say on making these decisions. And so when you're dealing with somebody who has this kind of brain damage, you can sort of see how that's starting to fall apart a little bit, and lawyers have to be aware of this brain damage and try to structure their choices and put the choices to them so that they understand the choices that they can make. The last one on there is rule breaking, and I think that one probably speaks for itself. Executive functioning, just continued here. I have what I think most of us understand: cannot learn from past mistakes, egocentric, impulsive, concrete thinking. Again, these are all things that lawyers really have to understand, and other people in the justice system have to understand that this comes from the brain damage. This isn't willful behavior. And I'll give you an example of egocentric behavior because it's a little bit amusing. A client of mine who was placed on probation, who was required to attend at her probation officer's office every Monday at 10 in the morning, and her probation officer wouldn't let her come at 1 o'clock in the afternoon, which she wanted to do because she needed to sleep at 10 o'clock in the morning. And the fact that her probation officer wouldn't change the order just made her, she just didn't understand that, and felt that everything should wrap around her schedule, which, quite frankly, I think she was right about, but certainly the probation officer didn't agree. And that led to a number of breach charges until she got a new probation officer who understood FASD, and then switched her reporting time to 1 in the afternoon, and suddenly she was making her appointments. So it's adapting to their behaviors with the understanding that they cannot help their behaviors, as opposed to asking them to adapt to our rules. In addition, I guess the other thing you have to look at here is cannot learn from past mistakes. One of the aspects of sentencing, certainly in the justice system, is that it has a deterrent effect on the offender, and that's particularly in adult. That's not actually a sentencing consideration in youth court, but it's still something that our justice system is premised on. And of course, if they're not learning from their mistakes, it doesn't matter what sentence you give them for stealing a car. That sentence itself is not going to prevent them from stealing a car in the future. So I'm sorry for those of you who are still following the slides. We're on page 4, and I'm moving to the middle slide. Again, I think most of these are they go without saying. Difficulty with cause and effect, difficulty anticipating consequences, difficulty understanding the perspective of another person, no remorse. That's a huge one because that's considered very negative in the sentencing context. And if the court is unable to understand, if the lawyer doesn't understand and then doesn't explain to the judge that the individual is actually incapable of putting themselves in another position, it becomes a very aggravating circumstance in terms of sentencing. The whole issue of requiring structure and consistency and having difficulty adapting to new situations. This is an issue that I find considerably when somebody is in custody. They are, of course, in a jail. There's a huge amount of structure. They're told when to get up. They're told when to eat. They're told when to go to school. They're told when they can watch TV, and they're told when to have a shower, and they're told when they can go to bed. And then they are moved from that into a non-custodial situation, and their whole thing goes haywire, and they can't follow through. And usually when they're taken out of custody into a non-custodial situation, they are still on conditions, they're still being monitored by the justice system, and they fall right apart because they have a hard time adapting to this new circumstance, plus they don't have the structure. The other situation where we see that with a lot in youth is young people who generally have child welfare status and who are bounced from placement to placement to placement. And of course, without any integration, without any ways of helping them adapt to the new placement, it just falls apart for them, and generally speaking, they end up on the street fairly quickly. I'm sure I'm not telling you anything you don't know about that. Then the last slide is talking about difficulty with time, memory, language, and social skills. Memory being a huge issue, again, for lawyers. And I think that most lawyers fall into this trap. They tell somebody once something, they tell them their rights, they tell them their choices, they tell them what's going to happen in a courtroom, and then they forget it within 5 minutes. And then the lawyer gets frustrated and says, I just told you that, and you're being willfully non-compliant with me, the lawyer. You're not listening to me, let alone everybody else. And because lawyers are pretty egocentric too, so it becomes a big, I think it becomes a big issue for them. So as a lawyer, you have to take some time to explain, and you have to anticipate that they're going to forget. So one thing at a time, explain it, get them to repeat it back to you, but don't be frustrated when they forget in 10 minutes and you have to actually go through this again with them. A big thing for lawyers is, we get what's called disclosure, for those of you who aren't lawyers, copy of the police report, all the witness statements. Often they're just given to the client. You read them and then come and discuss them with me. The client may not understand what's in there. It's important to read to the client, but it's also important to change the language. If you're given something, a police report or a pre-sentence report or something, read it to the client, but don't just read it verbatim. It has to be, you have to try and change the words a little bit and make sure that the person you're speaking to understands what is actually in the document. I've seen this because I know sometimes you can give somebody who has FASD a document and ask them to read it to you, and they'll read it to you and they'll pronounce everything right, and it sounds great, but then when you ask them to explain what it means to you, it all falls apart. So don't be fooled by the superficial ability to read or the apparent understanding of what's in there, because that's not necessarily the case. Talking about secondary disabilities, a lot of this comes from people who work with supporters who work with young people or adults who have FASD. And I'm just sort of highlighting some of the problems that they have had and bringing that into the justice system so that lawyers can sort of understand what kind of behaviors they can expect. So going into the second slide, this is one of the bigger issues, I think. It's hard to diagnose because many professionals do not recognize it. The fact that we are constantly demanding that people who have FASD change their behaviors, when in fact we need to change our behaviors and we need to change how we deal with those people as opposed to asking them to adapt to us. The fact they need to be constantly cued and reminded, I've sort of gone through that before. Easily distracted, that's of course a big issue frankly in a courtroom. And I know I've seen it when someone comes in who's in custody and comes into the courtroom. The courtroom's a busy place. There's a lot of people in there, a lot of people talking, saying things that the accused doesn't understand, and they're not paying any attention to it anyway because they're looking in the gallery and looking for their friends or their mom or their dad. So don't expect that they understand, that they're following what's going on in the courtroom. It's way too busy in there. You got to talk to them before they go into court. You got to talk to them after they go into court. And while you're in the courtroom, do try to keep the distractions to a minimum. For example, if you're doing a serious sentencing or something, you may want to do it when there's not a lot of people in the courtroom so that the young person has more ability to follow what's going on. One of the big issues, don't expect someone with FASD to improve after treatment. Again, we have to stop putting the onus on people who have the FASD. It's up to the rest of us to adapt instead of sort of saying, here's your treatment, fix yourself. We have to change what we're doing too. Masking, that's a massive issue, I think, again in court. Because, of course, we're busy people, lawyers, and we'll just say, do you understand? And they'll say yes. The police officers will say, do you understand? They'll say yes. The judges will say, do you understand? And they will say yes. And, of course, they're not understanding anything that's going on. So you really have to go beyond the simple, do you understand, and have the conversation with them. Again, the typical behaviors, they're followers, they're eager to please. And, the issue here about looking normal, and I don't like to use that word, but not showing any physical manifestations. I think that so many of people who don't show any physical manifestations slip through the cracks because there's some expectation that they will show those manifestations. And we talk about the IQ as well. The IQ, we have to look beyond the IQ, and we have to look at the behaviors. Because again, if you don't understand that an IQ could be within normal range and there still is brain damage and it still will affect the behaviors, you're not doing your client any good. Because believe me, a lot of people will just hang on to the IQ and say nothing else matters because their IQ is up there. So you have to go beyond that. Some young persons, but not all, have structure through school and parents, and this structure often disappears when they're adults. Of course, I think that probably makes sense to people. The expectation is, with most people, that once they go into the adult world, they're going to be able to survive without structure, and people who have FASD are going to fall apart without that structure, so you can't just say you're 18 now and things are going to go better for you. Getting into this issue with secondary disabilities, they often occur in people with FASD because they have difficulty adjusting to the realities and the requirements of daily living. These are considered inorganic characteristics as they occur through the individual's developing years and adulthood. I think that, again, goes without saying. And then the last slide, just sort of listing some of those disabilities. Addressing these disabilities often involve counseling. And as I've said, or tried to say, counseling requires insight. Insight is not something that people who have FASD are capable of doing, so they generally do not respond well to counseling. And then the reaction is they're not responding well to counseling, it's their fault. Again, we have to stop putting the focus on them, and we have to start accepting that we have to make some changes. So, page 7, just a couple of quotes. These are dealing with some legal issues. Of course, I think it's pretty obvious. If the structure was there, I think that we would have fewer problems within the justice system. We'd have fewer people in the justice system if we could deal with the issues outside of the justice system first. Then just going down, and I'm not going to go too much into these. I think you can see the slides here about the FASD key points and our responsibility to accommodate the invisible disability of FASD. It's something that I often talk about. Is we don't ask the person who's in a wheelchair to climb the stairs. That would be an impossible thing to put in a probation officer or probation order, for example. But we do ask the person with the invisible FASD to follow about 18 conditions in their probation order without any help to do so, and that's also impossible for them to do. And so we have to be aware and treat the invisible disability in the same way we treat the visible disability. The top of page 6 just talks about the cognitive-based therapies and the difficulty learning from past mistakes and difficulty linking cause and effect, which is why those kind of therapies don't work. This impacts the justice system, again, because when you're looking at somebody's history somebody in the justice system, when you look back at their history, when you're looking at situations like or sentencing order, or whether or not you're going to deal with a young person as an adult, whether or not you're going to make somebody, an adult, a dangerous offender, they can look back at all the previous counseling and therapeutic interventions, and they look back and they go, well, see, all these things failed. This person is not amenable to treatment. Therefore, we only have one option. Instead of saying, all this treatment has failed because we've never treated them properly. We've never given them the proper treatment, maybe because we've misdiagnosed them, or maybe because the treatment options we've given them are not the appropriate treatment options. So that's why it's important that we recognize this no matter what stage you're dealing with a client in court. If you're dealing with them early in court, early in their criminal career, so to speak, set the stage properly and make sure that orders are not given that are probation orders aren't given, or something that sets them up to fail. And if you're dealing with them late in their career, if you have an adult who has a lengthy record, and still investigate the FASD, and you may have to come to court and say, I know he hasn't complied with all these other therapeutic interventions, but it's because none of them have been the appropriate ones. It's like treating diabetes by cutting off someone's leg. I mean, it's a different diagnoses require different treatments. Now I'm just going to talk a little bit about the justice system. Just sort of for tips for lawyers, just common behaviors seen in the justice system, and then talk about how these behaviors impact within the justice system. So this is now on the bottom of page 6, and these are pretty obvious ones. Easily led by more sophisticated peers, multiple low-grade offenses, frequently with others, frequently arrested, generally the only ones who are arrested, the people who are sometimes peers bring them along and abandon them and let them deal with the police while the other people are running away. Offenses do not make sense, and we heard about one offense when we were in Victoria, at the conference in Victoria, about a young person in rural BC who stole some saddles from a farmer and then called the guy the next day and offered to sell them back to the guy. And when asked why he did this, he said, I knew he needed them. So obviously it doesn't make any sense, but if you're not thinking like the rest of us, then it makes sense it obviously made sense to that young person, but doesn't make sense to us. Impulsive, opportunistic crimes. For example, another client of mine who took a cell phone. He was partying at someone's house, and she went upstairs to use the washroom, and he decided he was going to leave, and her phone was there, so he left it. Not too smart, because of course she phoned the phone, and he answered it and said, "Oh yeah, it's me, and I took your phone," and so obviously he got picked up pretty quickly there and charged with that offense. Failure to change the strategy when something goes wrong, and as most lawyers will say, there's some of our clients who do the same thing over and over and over again. One of my clients consistently broke into the same neighbor's house, whether or not she was there. And because sometimes she was there, of course, it was considered a little bit more dangerous. Doesn't matter that she knew how he would break in. He always did the same thing. When he wanted money, he would go and do it. Again, fight or flight. Right to silence almost always waived, and even false confessions. And I'm going to talk a little bit about the confessions as we go on. No apparent guilt or remorse, and unable to appreciate the magnitude of their crime. On this, I can give an example. On the last one, when just a couple of years ago, speaking to a young person who was charged with second-degree murder, and here she was 16 years old. Under the legislation, she was automatically going to get an adult sentence if she was convicted, unless I can convince the court not to give her an adult sentence. And I was explaining that all to her, and she was like, okay, and shrugging, because obviously she had no idea. She couldn't understand it. In fact, in that case, the victim having been stabbed, when she was arrested, she was going on and on about how she's going to kill the guy. So obviously making some statements that weren't particularly helpful to her, and not noting that the guy had died several hours before she was arrested. Just some stats here. 60% of subjects with FAS or FAE had been in trouble with the authorities. As a criminal lawyer, that doesn't surprise me even remotely. I'm always more surprised that when I have a client who has FASD who doesn't come to us till they're 16 or 17 without a record, because to me that's a shock, and it's a nice shock, but it's a shock if it's taken 4 years for them to actually get charged with something. This is important for all lawyers to understand. Criminal justice system is based on the notion that criminals will be caught, punished, and learn from their mistakes. People who have FASD cannot learn from their mistakes. It's the basis of our justice system, and in my opinion, it makes, for young people or anybody who has FASD, the justice system discriminates against that disability because the foundation of the system is that they're going to learn and change their behaviors. And the system isn't willing to change its behaviors or make itself flexible for the accused. The accused is expected to make those changes. So, top of page 10, just a couple of quotes. I won't really go into all those details. But the second slide, this is, again, for lawyers. They really have to understand this. It'd be really nice, and in the ideal situation, is if your client has FASD, they're going to come to court and there's going to be a support worker with them, or a parent or a social worker, and they're going to say, Johnny has an FASD, and because he has FASD, here are his behaviors. That is hardly ever going to happen. And if the people out there who are caregivers, let me tell you that I think that's an obligation on your part to make sure that the lawyer understands that, because the lawyer's not going to necessarily ask those questions. For the lawyers, it's your obligation to ask those questions. Don't expect that people are going to tell you. This is a huge communication gap here, and it's a big problem. The other problem, though, is how many people come in who have FASD who have not been diagnosed, and that's I would say that at least half the time when lawyers are dealing with clients who have FASD, there is no pre-existing diagnosis. And although I think it's completely appalling that we have to wait for somebody to come into court and meet a lawyer who's not medically trained to actually start revealing the diagnosis of FASD, the truth is that's what happens sometimes, and we have to be, as lawyers, we have to be prepared for that. And again, I've gone on and on and on about these misdiagnoses, but this is a huge one. ADD, ADHD, conduct disorder, or oppositional defiance disorder. And they're so big, and particularly oppositional defiance disorder is so commonly misdiagnosed. And the difference is ODD requires willful behavior, and FASD does not. And so it's such a massive problem for people who have FASD to be misdiagnosed in these other ways. And so again, as lawyers, we have to be aware of that. And when I'm looking at a client and I'm told there's ADHD and ODD, my immediate thought is I'm going to check in to see what else there is. Because as soon as I hear that, I think there's a problem. And that doesn't mean I'm not a doctor, obviously, but I'm certainly going to look into that and see if it's not ODD and ADHD, but in fact something else. And then the last slide, again, is just some hints to lawyers. If your client has behaviors have not improved with treatment, you may want to look at different avenues here. And again, it's important to look at the assessment. And particularly if your client's charged with something very serious, don't just assume that the previous assessments are correct. Dig deeper. Now, doctors may or may not agree with me, but I will say as a defense lawyer that I don't frankly care if the diagnosis is FASD. What I care about is if a doctor or if a professional can tell me there's something organic, and that organic disability, that organic brain damage is affecting the behaviors and is not something that can be treated with conventional therapies. That's what I need to know. That's what lawyers need to know. And again, going back to the beginning when I was giving all the different lists of diagnoses, partial FAS or that sort of thing, it's important, if you're the person doing that diagnosis, if you're the person creating that assessment, that you let us know that what that means, and you let us know what that young person can be expected to do and what kind of behaviors you can expect to have. Because we're not doctors and we're not going to know that, and people are going to pick that apart, as I've said, and they're going to look at it and go, well, partial FAS, then clearly that person can function in such and such a fashion. We know it because it's only partial. So it's important that all the information is given to the legal system, the lawyers and the judges, so that the person is treated properly in the court system. The red flags, and this is a list for lawyers that they should really look at. Again, there's no validated screening tool. That's doctor talk. It's not my talk. I don't care if there's no validated screening tool. Look for these flags and go deeper. So, and then we just get into some of these things: the removal, involvement of child welfare, and removal from the family home. When the social worker is involved, I almost always ask, is there a history of alcohol abuse in the family? At this point, I'm not asking if mom was a drinker. I'm just asking, is there alcohol? Because that's one of the red flags. Sporadic school or work attendance, multiple diagnoses, again, sort of what I was talking about earlier. And again, just to remind everybody, just because, and if you are the support worker, the social worker, make sure the lawyer knows that there's a diagnosis. And if you are the lawyer, make sure you're asking if there's a diagnosis. Again, and this is a big one too, numerous administration of justice breaches. And it amazes me sometimes. It amazes me that I did this, and it amazes me that some of us still do this. If you have a client who has many, many breaches, there's something going on there. And we have to look at that. We can't just sort of say, oh, this kid is driving me nuts. He just doesn't do anything he's supposed to do. Throw him in jail because he's clearly not going to follow. There's something else going on there. And that's not to say that not everybody who breaches has an FASD. Sometimes people are willfully non-compliant, but we're not doing our job if we're not going a little further and checking into that. So the next slide, the middle slide, is the most important slide of the whole presentation. And I just lost it. Oh, there we go. Okay. Failure to recognize and properly respond to an FASD diagnosis could put your client at risk for an unfair conviction or an unfair sentence. There's nothing more important than that in this presentation as far as I'm concerned. So just going on there, in order to get an expert, FASD is going to affect criminal trials, fitness, admissibility of a statement, whether there's a defense, and sentencing. It's going to affect other things too, but I'm sort of focusing on the biggies. And you may, as a lawyer, find yourself having to retain an expert for FASD, and these are the areas that I think you may be interested in investigating and where it may impact your defense of the client. When looking for an expert on FASD, ask around. And I should say, and I'm going to go into this a little bit later, but just because one person says the individual doesn't have FASD, or just because a previous doctor has discounted the diagnosis, like what everybody else in the world, not every doctor agrees, and not all of them are right. So there's a case that I'm going to be referring to down the road where one doctor said no to FASD, the other doctor said yes to FASD, and so it was the battle of the experts in the trial. So don't just stop. Don't stop when one person says no. If you think there's a problem, you may want to get another opinion on that. This is just the different areas that I'm going to talk about how FASD may affect the process. So starting with arrest and detention, I find sometimes people who have an FASD may react quite violently to an arrest, which seems to come out of nowhere. But those of us who understand FASD also understand that there's tactile issues, they're very sensory perception issues. They don't like to be touched. You add to this, and you clearly don't have to have FASD for this part. But if the client is a victim of previous sexual abuse, then they also don't like to be touched. You just put these things together, and sometimes the reaction can be quite violent, and it can escalate from a very simple situation to a much more serious situation where now the person's charged with assaulting a police officer. Now they're getting handcuffed behind their backs, and then they're getting more angry, and then they're spitting, and then everybody's getting mad because they're spitting. So it can escalate quite quickly. The other problem is maybe over-cooperative, getting right up and saying it was me, being very providing far more information than their lawyer ever wants them to provide. You do have to understand that, of course, police don't always understand FASD. In fact, they rarely do. And I don't mean that as to denigrate the police, but when they're in the middle of an arrest and it's getting violent, they're of course going to react to that. They're human beings too, so if they think the person they're arresting is causing them problems, they're going to not necessarily be gentle with that person, and things can escalate quite quickly. So just going into statements. Statements is kind of it's a tough area as a lawyer. I had some problems finding the cases on this one. Two issues with the statements. Did the accused understand their rights? Is the statement admissible? That's one issue. And the other one is, was the statement true? And both of them become quite important in this discussion. Now, there's a case, for those of you who are lawyers, you probably know it. For those of you who aren't, you won't know it. It's called Weichel, because of course they have to have weird names. It's from the Supreme Court of Canada, and it talks about, in terms of the admissibility of a statement and whether or not the statement is voluntary. They talk about the individual, the accused, has to have the operating mind, and that operating mind does not imply a higher degree of awareness than knowledge of what the accused is saying and that he is saying to police officers who can use it to his detriment. You can see, again, how if you happen to be lower functioning or if you happen to be suffering from a disability that makes you wanting to please the person you're with, eager to please, susceptible to trying to think of the word, to suggestion, that type of thing. Obviously, somebody who has that kind of brain damage is going to be far more likely to give a statement than somebody who doesn't. So even this case law, even the law, as far as I'm concerned, discriminates and doesn't adequately consider this kind of brain damage. But that's a situation that we're faced with in terms of the legal situation as it stands today. The cases tend to focus on the conduct of the police. If the police have done something that is inappropriate, and they can look at they can judge the police's conduct by the accused. If the police know, for example, that this accused has fetal alcohol syndrome and is suggestible, and so they abuse that, then maybe the statement won't go in. But it's really up to the police. It's not. They don't really look at. The police can do everything right, as I think we all understand this. The police could do everything right, and still the individual being questioned won't understand the question, won't understand that they're waiving their rights, or won't understand what they're doing or the implications of what they're doing. And the way the case law stands right now, it appears that if there is such a focus on the police that those statements would likely go in. There are a couple of other cases that I think people should understand, so I'm going to just give you those. I don't have them on my handout, so for those of you who are interested, one case is called R versus Henry, and it's 2003 Yukon Judgments 1737. And there's another one from Manitoba, R versus Friesen, Friesen, and that's 2007 Manitoba Judgment 364. In the case of Henry, an expert testified and said this person didn't understand the rights that were given to them, and in that case the statement was excluded. In the course of Friesen, the statement was admitted. Not only that, but the judge actually used the fact that the accused had FASD to explain why the accused gave details of the offenses, which were arson, that were different from the actual facts. The accused said he did something that clearly he didn't do, and the judge said, well, he has FASD, so that explains it. So the judge found that the statement was probably true, and that to the degree that the individual admitted committing the arsons and therefore admitted the statement. So FASD can obviously work in two ways. I think it's, again, from my perspective, I would say that the most important thing you can do is get an expert to speak to the individual, assess the individual about how that person, how your client would have been able to understand the rights that were read to them and be able to understand the statement that they're giving. And it has to be unique to that person, to your client. It shouldn't be a general information. It needs to be directly about the individual you're dealing with. So, and just going on there's another case. I won't go into all the details, but in this is the case R versus BSM. This is the case where there was the battle of the experts. So, again, not every expert agrees. And in this case, the judge found, I don't know if the judge actually made a finding of fact in terms of whether or not the individual had FASD, but certainly did not admit the statement and found that the young person didn't understand the rights that were read to them. So and I should just explain something here for those of you who don't know. The admissibility of statements for adults is different than admissibility of statements for young people. It's much harder to get a statement in for a young person than an adult. So young people have far more protections. And at the top of page 15, that's sort of what I'm talking about there. The first case from Manitoba, Court of Queen's Bench from 2006, in that case, the statement of the young person was admitted. In that case, the experts didn't give evidence specific to the young person. They just talked about FASD generally, and the judge listened to the young person testify and assessed that young person and assessed his evidence and decided that he didn't really fit with what the experts were saying, so admitted the statement. The second case here is a Supreme Court of Canada decision from last year, and that's what I'm talking about in terms of change in the law for young people and statements. In this case, the Supreme Court of Canada has decided that when you're dealing with young people, the police have to make a reasonable effort to be aware of disabilities, and they have to prove beyond a reasonable doubt that the young person, that there's compliance with the admission of the statement. So I think the first case would it have been decided differently. The Manitoba Court of Queen's Bench case would have been decided differently had the Supreme Court of Canada decided the second case before the first case, if that makes sense to you. I hope it does. The second slide there talks about reliability, and this is another issue with statements, because you have to not only be voluntary, they don't have to just be willing to make the statement and doing so understanding all their rights, but you have to expect that the statement can reasonably be or is true. It has to be reliable. And so I've just cited a couple of cases there where somebody who has FASD made completely false confessions, and particularly the second one concerns me because I think, and I don't think it really surprises anybody. He was questioned and questioned and questioned by the police, and finally he just told the police what they wanted to know. And what he did is he repeated what the police told him. So he made a false confession, spent 11 months in jail for something that ultimately everybody found out he didn't do because he was somewhere else at the time. So I don't think that's unusual, unfortunately. So again, lawyers have to be really aware of these issues and not just think because the client made what would otherwise be considered an admissible statement, that doesn't mean the statement is true. Issues that must be identified to the lawyer, issues the lawyer may have, client interview, and then just starting to talk about fitness to stand trial. The first part of this, issues that must be identified to lawyer, that's to those of you out there who are support workers, parents, social workers, or whomever, for individuals who are entering into the justice system. This is your job, as far as I'm concerned, to tell the lawyers. And you have to tell them about this client's ability to provide a linear account. Can they talk? Are they able to speak in a linear fashion, which I think most people are not? Ability of the client to understand what's important to the lawyer, and the ability of the client to understand his or her rights. I'm sort of generally speaking this way, but essentially what I'm saying is if you're dealing with somebody, if you're supporting somebody who has FASD who's coming into a courtroom, you need to talk to the lawyer about what kind of disabilities that person has and how the lawyer is going to have some difficulties explaining things to that person. Because the lawyer, you may be coming in there and saying, you just tell me, lawyer, and I'll explain to him, but the lawyer has to explain it to the person, has to explain to their client. Sometimes they have to talk to their client without you there. So you have to identify this stuff to the lawyer so the lawyer can adequately communicate with their client. And then just to go on sort of on the same vein, issues the lawyer may have, and I'm talking about this, they have to be able to effectively interview their clients. So lawyers have to think outside the box and talk to their clients in ways differently than maybe they would talk to other clients. Provide options in a manner they can understand. They have to consider whether the client is fit to stand trial. Have to ask if the client is able to effectively understand what is happening in the courtroom, and they may need to explain things before the courtroom and after the courtroom, so they may have to say things more than once. In fact, they will always have to say things more than once. I won't even put an A on that. A lot of this comes from a website. For the lawyers out there, there's a website that's indicated on the bottom of this slide, and it's a really good one. So I've just sort of copied it and said, here are some points you need to look at. Keep statements and questions short and to the point. Provide information in small pieces and ask for information in the same way. Ask a question in several different ways. This comes back to don't ask them, do you understand? Probe them, ask them different ways so you really know if they understand it or not. Keep communication concrete. I like this example. If you ask someone to make a bed, he may think you want him to build a bed. That may be kind of simplistic, but it's also, I think, the way you have to think. You have to understand that you can't be giving them complex questions. You have to make things very straight and to the point. Read material to client. I've sort of went into that before about how you can't expect them to understand the language, understand the words, even if they can read the words. Again, client interview, avoid pronouns, use names, use visual aids as much as possible. I know in Manitoba, in the probation area in Manitoba, they actually have developed pictures to explain probation conditions to the young offenders who have FASD. So because just reading them out and saying it to them doesn't necessarily have the same impact, but actually drawing a picture of a cell phone with an X in it means you can't have a cell phone. So and apparently they're quite effective. Always confirm that what they heard is what you said. So ask them to repeat back to you, but if they're repeating back to you verbatim, ask them to explain it differently. Ask questions about the content, not if they understand. Allow client more time to respond. Try to have the interview in a quiet place. And that, I'm a courtroom lawyer, and I go to court all the time, and sometimes the first time I meet my client is in court. And anybody who's been around youth court in Edmonton knows that outside that docket courtroom in courtroom 444, it's just insane. And sometimes it's quieter, but usually there's 5 or 6 different lawyers running around. There's probation officers. There's 50 kids running around. And to pull your client aside and talk to them, blah 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 blah, say these things. This is what we're going to do in there, and you do it very quickly and go into the courtroom. Your client's just looking at you, going, "Whatever, man," because I don't know what you said. So you have to try and be sensitive to this and take them out of that arena and talk to them where they're not going to be distracted. Okay, so the first issue I think that any lawyer has to deal with any client, most of our clients are fit to stand trial, but it's the very first thing, because if your client is not fit to stand trial, if your client is not capable of following what's going on in court, then it's going to impact everything you do in court. You can't take instructions from that client. So it's the first thing that all lawyers have to consider. Now, with FASD, this case that I've cited here is from the Saskatchewan Court of Appeal. It overturned a lower court decision. The lower court said that Mr. Job here was not fit to stand trial because he had FASD and he had some difficulties understanding what was going on. The Court of Appeal said that's true. He does have issues understanding what's going on, but it's such a low threshold. All he has to do is be able to talk to his lawyer and tell him what happened. He doesn't need the capacity to determine in his own best interest. So again, we're getting into a situation where people who have these cognitive deficits, in a sense, are discriminated against by the justice system because they can't make these. They're considered fit to stand trial, but they're not necessarily have the cognitive abilities to make their best decision for themselves. That said, the way it works with your unfit to stand trial is you actually, the individual who's found unfit gets remanded to a mental health hospital, and if that person is not fit because they have FASD, then chances are they're never going to be made fit. And the other problem is if they're a danger to the public, then they're never going to get out of the hospital. So I will say as a defense lawyer that it would be very rare that I would want my client to be found unfit to stand trial when the source of that lack of fitness is an organic brain damage, because I know that no medication is going to make that person fit to stand trial, and they may spend the rest of their lives in the hospital. So I would suggest as a lawyer, we're obligated to look into that, but as a lawyer, I don't think it's in our client's best interest to be found unfit to stand trial. Conduct of the defense, the role of FASD in the conduct of the defense. First thing you should know is it may provide a defense to the charge. In this case, and it's a very, what we call in lawyer speak, a very fact-specific case, but in this case, the individual had been diagnosed with FASD. That expert came to court and described to the court how that diagnosis would affect that individual's thought processes. And because of it, the court was ultimately decided that person may not have formed the intent to kill, even though he stabbed the victim, I believe, on more than one occasion. So had he been what we would call a normally functioning individual, the very fact that he stabbed somebody that many times would probably be enough to convict him. But when you have this kind of brain damage, that's where the courts were saying, well, maybe there was no intent to kill, and because of that, I can't convict him of murder. He did convict him of manslaughter, and then when it came to sentencing, the FASD was considered an aggravating feature in sentencing, so he got a sentence on the higher end range of sentences, because he, of course, could not be treated for his FASD, and he was considered a danger to the public. The other thing the lawyers would have to consider are things like when a conviction is based on whether or not the accused is willfully blind. For most of us, if my cousin came up to me tomorrow and I knew my cousin didn't have a job and he had keys to a brand new Lexus and he told me to take it for a ride, I would probably figure out that it wasn't his Lexus and maybe he stole it. If you have an FASD, you may not figure that out. So again, that's something that lawyers have to be aware of. If there's a diagnosis like that, then there's no willful blindness. It's more likely that your client actually believed that your cousin owned that car and had the right to give you the keys and let you drive it. So it does impact the defense to the actual charges, and lawyers have to be aware of that. A bigger thing is that lawyers have to be aware of is what they're going to do and how they're going to conduct this trial. Should the client testify? I have never had a client of mine who has FASD testify in court, and so far I haven't had to worry about it, but eventually it's going to happen. I don't want to put my client who has FASD up on the stand because I know that no matter how I deal with him on the stand, when that client is cross-examined by the prosecutor, the prosecutor is going to suggest things to him and the client is likely to agree because that's the way it is. So what I think lawyers have to consider is whether or not they wanted to make an application to call expert evidence, to have the diagnosis and the disability explained to the court prior to their client testifying. Now, I say that I've never done it. I've never seen it done. But I think it's something that lawyers, when you're faced with that situation, it's incumbent on you to at least investigate that and see if you can make that application and get that evidence in. Again, and this is, of course, when you're talking about trying to get your client's version of events, consider the client will have issues with memory and time. Again, as I was saying, they're eager to please, likely to change his story at the urging of the Crown. And if the court doesn't understand that the client has FASD, they may be left with a negative impression of the client after they testify, because of course they're going to give however many different versions of the story as have been given to them. And I can speak to that again in terms of an example. My client, who was charged with murder because she stabbed somebody, gave one version of the events to the first lawyer who went to speak to her, gave a different version of the events when I went to speak to her, gave a third version of the events when I had a doctor come and assess her for FASD. All of those events, all those versions involved her acting in self-defense. But all of them, every version was different. Every version had the stabbing occur at a different time, and the victim was doing something differently in each version. So it's not that I didn't believe her, because I did, and ultimately the charges were stayed, so the charges were withdrawn, so she wasn't convicted of this charge. But faced with a situation like that, I know she's going to give different stories. I wasn't quite sure how I was going to have to deal with this in court if it came to that, if I actually had to put her on the stand. So these are things that you have to be aware of. If I had put her on the stand without any supports at all, without any sort of evidence, she would have given probably a fourth and then maybe a fifth and maybe a sixth version of this, and she would have had a very difficult time being found not guilty. So the second slide here is talking a little bit about, or not a little bit, we're talking about guilty pleas now. When a lawyer pleads their client guilty, when they have to explain, they have to make sure that the client understands what they're giving up when they plead guilty. So they have to understand that the plea is an admission of guilt. They have to understand the nature and the consequences of the plea, and they have to understand the court is not bound by any plea bargain. Now, in fact, this is a much higher onus than fitness. So we go back to the fitness test I was talking about earlier. There's very low onus, very little that they have to actually explain or that they have to be able to do in order to be found fit to stand trial. But it seems that in order to accept a guilty plea, they actually have to understand much more complicated things. Now, if I actually, and I do have concerns that my clients don't understand these three things in a way that's appropriate, but if I strictly adhere to it, none of my clients could ever plead guilty, and that's not in the best interest of the client either. So in some way, you have to be able to explain to your client, because this is the important one, that they're waiving their right to a trial when they agree to plead guilty. And to have them waive their right to a trial, they have to understand that even if they did it, they don't have to plead guilty. Now, it's hard enough for most people to understand that, to be quite honest. Then when you have with somebody who has difficulty understanding abstract concepts, it becomes a very difficult thing to try and explain. Sentencing considerations. There's, I sort of broke this down a little bit between young people and adults, and then I talk a little bit about the different factors that lawyers should consider. Youth sentencing. Young people are covered, I already told you they're between 12 and 17. There's a separate piece of legislation that covers young people who come into conflict with the law, and that's called the Youth Criminal Justice Act. And in that act, there's a totally different sentencing regime, totally different sentencing considerations for young people than there are for adults. So this slide here on the middle of page 20 sort of generally gives you the different kind of considerations. They have to consider, obviously, a criminal record and the seriousness of the offense and the harm done. But the sentence has to be the one that's most likely to rehabilitate the young person, and they also have to consider all of their sentences other than custody before a custodial sentence can be imposed. So for a young person, they have to, generally speaking, the courts, before custody can be imposed, they have to order a pre-sentence report, and often they'll order a psychological or psychiatric report. This, as I say here, may be the first stage when anybody discovers that the young person has FASD. As a general rule, and I consider myself quite well educated in this subject, but that doesn't mean I always discover or realize that my client has this disability until later on in the process. And sometimes what will happen is I'll read the pre-sentence report and I'll realize these behaviors are coming out in this, that are being set out in the report cause me some concern, the red flag, and so I'll send the client back to do an FASD assessment and have it come back with a diagnosis of FASD. I would also point out that when you're dealing with young people, they have to you have to consider the harm that's caused, but you also have to consider whether or not that harm is reasonably foreseeable. And again, with somebody who has FASD, what is reasonably foreseeable? Are they aware that kicking somebody 5 times is worse than kicking somebody 2 times? Are they able to follow through to the logical consequences and the logical outcome of their conduct? And that becomes an issue, I would suggest, and something that you would have to check with your expert and have them consider that. When they're an adult, different sentencing considerations, and one of the primary considerations is the protection of the public. So what was a mitigating factor when the young person was 17 is now an aggravating factor now that they're 18, and it's a real difficult adjustment for them. And I'm not sure how much we require some sort of transitioning there, I think, because it's causing a lot of problems for people once they turn 18. So anyway, this first slide sort of discusses the different considerations in adult courts. What I suggest to lawyers, we have to catch this early, and you really have to catch it, hopefully, while the person is still a young offender. What we need to do is we need to get them out of the justice system. We don't need to keep them in there. And a lot of people bring people into the justice system looking for assistance, and particularly young people, because they think we have this, and we do, we have this lovely youth justice system, and it's there to help and rehabilitate. And so a lot of well-meaning people think, okay, we're just going to charge Junior with destroying the house because that way he can come to court and the judge can get involved and we can get a probation officer and we can get him some help. And really what you're doing is you're building a criminal record and you're not getting him help, because that's not what the justice system is there for. It's there to punish criminal offenses. It's not there to get them help. We need to find sources for that help outside of the justice system. We really need to do that, because what happens is, as I say, they get criminalized, then they come into the adult system, and then we're losing them. So for lawyers, you really have to try to identify this when your clients are still young offenders and try to advocate for supports outside of your justice system. Don't fall into this trap that it's okay to have them charged and we'll just get them some help in here, because in the long run, I'm not sure how effective that help is for them. So, to promote a sense of responsibility in offenders and acknowledge the harm done to victims in the community. Again, I'm not sure that people who have FASD are capable of doing any of those things, no matter what kind of sentence is imposed. The sentence has to be proportionate to the gravity of the offense and the degree of responsibility of the offender. And that's also, again, degree of responsibility. There's obviously the physical degree of responsibility. We know that offender X was the one who broke into the house, but you have to also look at, and that's really what the court's going to look at. But I think as lawyers, we have to making sure we understand that the courts understand if offender X has broken into the house because 3 other guys have told him to go do that, and he's susceptible to that kind of urging because of his disability, it's incumbent on the lawyer to make sure the court understands that. Now, in sentencing considerations, on paragraph 22, we have to look at the different kind of sentences that can be imposed, and this is both on young people and adults. And I think a lot of people, when we look at probation, I think a lot of people mistake probation for structure. They think this person needs structure, so let's get him a probation order and let's put 18 to 25 conditions on him, and Junior's whole day is going to be regulated, and that's going to help him. Because without somebody out there helping him do all these things, all you're doing is setting them up to fail and making sure that this guy is going to get all kinds of breaches of probation. And with breaches of probation come ultimately custodial sentences. So don't say that probation is structure. Probation is rules. Structure is structure, and that's something else, and that's someone helping them. That's someone providing them a home, providing them with guidance, with help deciding to make their decisions. It's not providing them with rules and being hands-off. So, and again, as I sort of say here, too many conditions or complicated conditions may be setting your client up to fail. And this becomes a little bit more serious when you're looking at what's called a conditional sentence or deferred custody. For those of you out there who don't understand what those are custodial sentences, but the person is allowed to serve those sentences in the community. They tend to be very strict conditions, and they are very strictly enforced. So, yeah, your client might be happy because they're going to get a sentence that's going to be out of jail, but you're doing them no favors because chances are they're not going to comply unless there's somebody there to help them comply with those conditions. They're not going to comply, and they're going to end up being breached, and then they're going to end up coming back into custody and serving a sentence anyway. So it's important you consider those factors before you just start leaping to a probation or a deferred custody or conditional sentence. And then when you talk about custody, of course we know they're susceptible to the people around them. And the thing I find with youth, because that's who I deal with, who have FASD, is you can often have a young person, I was talking about this earlier, a young person who is in their teens who has not ever been in trouble, and as soon as they come into custody, and as soon as they meet these people, even if they get them out of jail, now they've got new friends, and those new friends actually look up to them for the offenses that they've committed. They actually think it's cool that they went and punched some guy in the nose or broke into a house. And so that's a positive reinforcement for them. That's something that they did. They were looked up to for it. They find those friends again, and suddenly now we're getting them into this cycle of committing crimes and committing crimes. And I know, just as an aside, I know that people who have FASD have a hard time finding friends. And I know that I can speak to a little bit of experience because I have a 14-year-old niece who told me this weekend she has a person in her class who has FASD. And of course, they all think he's weird, and he misbehaves, and he's attention-seeking, and so he has no friends. And so you go into a situation like a custodial facility where that kind of behaviors they exhibit actually draw their friends and create friends for them. That's when they're going to start behaving in that fashion. So custody isn't a good option either. I mean, obviously, we're stuck with it. We're stuck with all these sentences when someone has to be sentenced. They have to be sentenced to something. But you really have to consider when you're putting somebody in custody what the repercussions will be. And then when we have the situation when they get released from custody and if they don't have the transition, if they don't have some sort of supports helping them out, then you're just setting them up to fail when they get out as well. So just some factors that lawyers should consider. try to work together with the Crown. The first person you should be trying to convince about your client's disability is the Crown prosecutor, not the judge. So you need to go to them and you need to bring the reports to them and you need to say, let's work together and try and craft a sentence that we can both do. Now, that's not to say that all prosecutors are going to agree, but that's who you have to start with. And again, then this is very important. If you fail to factor your client's diagnosis into the sentencing process, your client could fail and end up with multiple breach charges or in custodial sentences. And again, with this issue about finding them assistance, if you know your client has a parent that's going to help them get to the appointments once a week and that type of thing, then they're more likely to comply with it, and you can feel more comfortable about it, having that type of sentence imposed. Again, and I've sort of said this before, aggravating or mitigating factor. In youth court, it's usually considered a mitigating factor. In adult court, it's considered an aggravating factor. And there's one more aspect of this that I don't talk about in the slides, and that's when a young person is charged with an offense that's serious enough that may involve the transfer to an adult, to get an adult sentence or transfer to adult. An FASD may it will depend on the judge. Sometimes it'll be considered mitigating. The young person can't help that they're brain damaged. But on the other side of it, if the court is concerned that this person is going to be an ongoing risk to society and cannot be treated, then it may be more appropriate that they get an adult sentence, and of course adult sentences for the most serious offenses involve life in prison. So judges may be more inclined to find an adult sentence is appropriate, because that way you keep them out of society's way for the rest of their lives. So it really does go both ways. And again, this issue here about need for structure, I've talked about this ad nauseum, I know, but some courts will find they need structure, so jail's the way to go. And as I indicated before, that's great for the time they're in jail, but then it makes it actually worse when they get out, because they've gone from high structure to no structure at all. And that actually can cause more problems than if you just kept them in the community in the first place. And just in terms of potential tools for sentencing, the Justice Support Project for Youth with FASD, that's a project that I'm involved with. We only deal with young persons, but we find it works very effective. It's an effective tool to use when you know that your client obviously has pled guilty or has been found guilty, and you want to make sure that they're going to be able to get through the sentencing process without getting any more charges. So what we do in that process is we have the person who did the diagnosis, we have generally the probation officer, people from the custodial facility, people, social workers, sometimes parents, sometimes not parents, depending on who the caregiver is, and schools and that type of people. They all meet and have a meeting and discuss the diagnosis. And that's an opportunity for the person who did the diagnosis to explain to the people who are going to be administering his sentence what this person can do and what they can't do. So what I've found is that it ultimately has led to a lot fewer breaches of their probation order or whatever, because the probation officer understands that this person cannot come to their probation appointments every day at 10 o'clock in the morning. That's too early for them. So we have to adjust and make it 1 o'clock in the afternoon when they can come. So it's that type of thing, and it's been an effective way to sort of reduce people coming back into the system. It's a project. It's partnered with our office, the Youth Criminal Defense Office, the Crown's Office, Probation, Solicitor General, and other people in the community, the Child Welfare and Edmonton Public Schools. And it's all voluntary. So there's other programs that are similar to that, I think in BC and in Manitoba. But those programs, they're more intensive, but they have money, and we don't. But you can do it. Again, my point is you can do it even if you don't have the money, if you have the willingness and you have the people who are willing to come and help these young people get through their sentences. Things you need to know. This is things that I've given for lawyers, but I don't think it just necessarily applies to lawyers. Because the most important thing is the justice system is not an effective way to manage the behavior of a youth with FASD. And I go back to this. don't think that getting them charged and bringing them into the court system is the way to help fix this person or a way to get this person help. Because in the long run, it may be, it's possible it may help in the short term, but in my experience, in the long term, it actually causes more problems than it cures. Consequences in the justice system are rarely immediate, and so we're looking, we hear this thing about how people who have FASD can't connect their sentence, their consequence with the offense. Well, of course they can't, and it's even worse when they're not getting sentenced until 8 months after the offense actually occurred. You're not teaching them anything. And of course, if they're acquitted, certainly not teaching them anything if they're found not guilty, because they're not going to get sentenced at all. There's a parenting system, and then there's a justice system, and they should not be mixed up. Okay. And again, the supports provided by the justice system are time limited. So even if you do set up this lovely case plan and the person's on probation and that probation order is providing them with counseling and these type of things, eventually that probation ends. So if you have no game plan, if you have no plan for what's going to happen after the probation ends, then all you've done is given somebody 6 to 9 months of supports that are disappearing. So it's important to find those supports outside of the system. Bringing someone into the criminal justice system may result in a criminal record. I say may because sometimes they're found not guilty. But generally speaking, it is in the criminal record. And then, as I've tried to explain here, as you go along in your career in the justice system, that record gets longer and the impacts become more serious, and particularly when they become an adult offender. They also make some bad friends. I think we all understand that. And then when they become an adult, there's fewer sentencing options. They're more likely to end up in custody. You're not going to get creative with probation orders. The older the offender is, the less creative we can get, and the more it's just going to be a custody sentence. Sentencing considerations in the adult system are much different. And I've said this before, it's mitigating in youth court, aggravating in adult court. The most important thing, I always say everything's the most important thing. This is now my third most important thing that you have to consider. This is important for lawyers to understand this. Do not judge. Don't judge mothers because their child has FASD. We don't know why, how this happened. We don't know what this woman's life was like. We have no idea what led her to consuming alcohol. It's not our business, and it doesn't matter, because the reality is, if we keep focusing on blaming other people, then we're not doing anything to help the person that we're dealing with. What we have to do is take responsibility for what we can take responsibility for. We have somebody, we're dealing with somebody who has FASD, we have some responsibilities to that person, and that's where we should be going, and not focusing on being negative towards other people. Again, just things you need to know in terms of how you're dealing with your clients. Explain things to your client more than once. And I've talked about this before. Explain to them before they go into the courtroom. Explain to them after they go into the courtroom. Ask them if they have any questions. Don't make them feel stupid if they have questions. Make sure that don't be sarcastic or whatever with them. Just let them ask their questions and be open and allow those questions to be asked. People with FASD tend to be easily distracted and overly stimulated. That's something, again, I was sort of talking about how when they come out of the cells into the courtroom and all this stuff is going on. They may appear that they're not taking things seriously. It's because they're not following it. And again, it's our job as lawyers to make sure that we help them bring them back on track. And it's our jobs as lawyers if the judge is getting upset because it appears that your client isn't following things. You need to explain to the court that your client has this disability and is having trouble following because of that. And we're talking about the external brain, and a lot of you people out there who are not lawyers will understand this. But again, we're talking about if we're going to talk about providing structure to people, then we have to talk about providing something external and something to help young people comply. And again, as I've said before, there's no point getting your client a probation order with 18 conditions if you don't have somebody there that's going to help them comply with those conditions. Because they're going to walk out of that courtroom and forget every single one of those conditions. You need somebody who can cue them and who can remind them, today's the day you see your probation officer. Today's the day you go and do your community service work hours. So I'm not going to go into all the details of this slide. Sort of talks about how an external brain, a support person can help somebody who has FASD. And this is just, I'm pretty much finished, I guess. I have a list of the program models and things that people might be interested in, and then my bibliography. But I just want to say a little bit at the very end, just talks about my contact information is at the end. So my phone number's out there, my email's out there. So if anybody has any questions, please call me. If you are somebody who's supporting somebody who has FASD and that person is in court, and you're not confident or sure that that lawyer understands what's happening, please ask that lawyer to call me. I'm more than happy to provide them with any assistance that I can provide them. Then just wanted to it's a little easy for us, and it's in our office. The Youth Criminal Defense Office it's a publicly funded law firm. We're all lawyers who work for this law firm, and we have youth workers who work there. We're a little different than other law firms. So we take a very holistic approach to the defense of young people who come into conflict with the law. We have a lot of resources, and I'm telling you this because I want people to understand to please feel free to contact me. That's my job. My job isn't just to represent the people I represent. I'm there to help as many people as I can. So it's a free resource, it's a legal resource, and people should feel free to contact us. And that is it.
So I'd just like to thank you very much, Pat, for presenting today. Got no questions coming in through the texting or through the email, but if any do come in, I will forward those on to Pat as well. And the next session actually has been canceled. That was on April 29th. So the following session will be on May 5th. 9 to 11. And so thank you everyone very much for signing up today, and we'll see you in a couple weeks.